Hello, everyone. My name is Salva, and I'm going to be your host for this podcast on the law of wills and what you need to take into account when you're making a will. Now, this podcast is intended to help any community worker understand some of the things about wills, what they should take into account and what they should avoid. Now, I'm going to talk to two of our expert lawyers at Citizens Advice Bureau. One is Stacy Price and the other is Daniel. Come on, Daniel, say hi to everyone there.
Hello, everyone.
Hi.
Okay, that's good. Okay, now before we begin, we'd like to acknowledge the traditional owners of the land that we are recording this podcast today, the Noongar people, and pay respect to their elders past, present, and emerging. Now, before we start, I would like to talk to you something about Citizens Advice Bureau, as some of you may not be familiar with our organization. We are a community legal centre located in Western Australia. Our head office is in 25 Barrack Street, Perth, and we have 7 branches in the metro area and 2 regional branches in Bunbury and Busselton. Now, we service the whole of Western Australia, and people can access our service by either coming to Perth and having appointments or going to one of our branches for appointment. We service the whole of Western Australia and assess and if you want to use our service, we do not means test clients, as we believe everybody is entitled to legal advice. Now, clients can have telephone appointments or they can communicate with us by emails also, even if they are living in different parts of Australia and overseas. We have assisted clients living in New Zealand, New South Wales, and even America by taking instructions by telephone or by email. Now, at CAB, we provide initial legal advice and draft documents such as wills, enduring power of attorney, enduring power of guardianship. Now, we do also draft some family court documents such as application for consent orders, initiating application, or responding to initiating application. In addition to all this, we also draft applications for probate and letters of administration. Now, one thing that we do not do is represent people in court. Now, today, despite doing all these things, today we are going to restrict the podcast to only wills, what you need to know in order to have a valid will. So this podcast will explain the nitty-gritty of law. Now, having said that, please remember that the information that is provided is general information and it's not legal advice, and we strongly recommend that you obtain professional legal assistance when drafting wills. Now, if you or your clients want to make a will, please contact Citizen Advice Bureau on 92215711 to make a legal appointment. Okay, now having said that, it's easy to, we are going to talk about wills. As I said, you may become overwhelmed with all the information we are providing, but we are trying to distill it into certain individual points that are important. Okay, as I told you before, and Stacy and Daniel have already introduced themselves. So here, let's start with Stacy. Okay, Stacy, can you tell me what is a will?
Okay, a will is basically a legal document that can do a whole range of different things, but probably most importantly, it sets out what you want to happen to your assets or your estate after you die, and it appoints a person called an executor to carry out those wishes as set out in the will. So it basically gives you the power to say who gets what out of all of your stuff.
Okay, so now I've heard some strange cases of people using recorded videos as their will or even text messages. So Daniel, can that be considered as a valid will?
It's a yes or no answer. So yes, those things have in the past been considered valid wills in the court, but the key word is there, in the court. That's because those things have had to go to court, and they've typically cost the executors or the people trying to use them as wills large amounts of money. So yes, they could be considered as wills, But if you're trying to make a will, I'd really just suggest that you try to make a simple, formal will that doesn't entail any complex court proceedings.
Now that makes a lot of sense, okay? Now, Stacey, what are the requirements for a formal will? Because Daniel have just said, don't try to avoid doing a video will or a text will, okay? So what are the formal requirements for a valid will?
Well, there are 4 important requirements for a will to be formal in Western Australia. So obviously, the first one is that the will must be in writing. Secondly, it must be signed by the will maker, so that's the person who's doing the will. Thirdly, the will maker's signature has to be witnessed by 2 independent witnesses. And the last thing is those witnesses both have to sign the will as well.
Okay. Now you said that the will had to be signed by the will maker. What happens, okay, let's say if I have a client, if someone has a client who can't sign, like they're a quadriplegic, or they may not know how to use their hand. For whatever reason, they cannot sign. What will happen in that case? Can they have a will?
Yeah, well, in that case, the will can still be formal if it's signed by someone else on behalf of the will maker. But with those sorts of wills, they usually require a special signing clause. So it's a good idea to have a chat to a lawyer if you need something specific like that. So don't try and do it yourself.
Yeah, that makes sense. Daniel, I have heard people are very suspicious. Superstitious, okay?
Very suspicious too.
Superstitious. They believe that if they make a will, they'll die soon. So they completely avoid making a will. Now, what happens if they die without making a will?
So if a person dies and they don't have a will, they're called intestate. So their estate is deemed to be intestate. So when a person's intestate, obviously their will isn't there to distribute their assets. So the law steps in and the law says how their assets are going to be distributed. So in Western Australia, we've got the Administration Act, and the Administration Act says what happens to a person's assets if they die without a will.
So what does the Administration Act basically says? Daniel, can you go into detail about that, please?
So what the Administration Act says about intestate people is it basically sets out a little schedule or a hierarchy of people who are entitled to take an intestate person's estate. So like if you had maybe a spouse and some children, the spouse would get the first 50 grand or first $50,000 and a bit of interest on that, and then anything left over afterwards is going to go, between the spouse and the children in certain percentages depending on how many kids you've got.
Now, what happens if that there is no spouse or children? Does that mean that the government will get everything?
In very rare cases. So if you had a client who maybe someone they know has died without a spouse or children, then it's going to go down that hierarchy we talked about before. So that might be the deceased person's maybe parents, maybe brothers and sisters, or maybe if they've got nieces and nephews and the brothers and sisters have passed away, those people instead. It's a big long list. Your client should probably get some legal advice about who's going to be entitled in that particular situation.
So the government doesn't get everything?
Only if there's no one.
At all. Okay,
Yeah.
Now I understand. Now, Stacey, you were talking about something the other day which may be of interest. What was that?
Yeah, a really common situation that we see at Citizens Advice Bureaus where children, so adult children, have come to us and their parents have died, but they haven't left a will. So the distribution of the parents' estate has been really different to what they wanted to happen or what they expected. Daniel, I think you were telling me something about that the other day. You might have had a client like that, or...
Oh, I think I was, Stace, yeah. So, I had a client the other day. I can't remember her name now. Probably shouldn't say it anyway. Basically, her father had passed away a couple of weeks ago, and the father didn't have a will. He talked about doing one all the time. He'd always said, you and the client had 2 siblings, so, you and the other 2 will get everything I own. And that's fully what the client expected to happen. But unfortunately, when she came in and saw me, one of the things I noticed on the death certificate was that a de facto partner had been listed. And so I asked her about that, and she basically said that, her dad had been living with a de facto partner. So, kind of like someone he was married to. They obviously weren't married, but they were living in a marriage-like relationship. for about, I think it was 4 years maybe. And so basically with the Administration Act, what happens is if a person doesn't have a spouse, but they do have a de facto partner who they've been with for more than 2 years, then that de facto partner basically takes the share that the spouse would have taken. So the client, who was fully expecting that her and her siblings would be getting the whole of the estate, kind of got a bit of a rude shock, because all of a sudden this de facto partner, who her dad had only really been with for a couple of years, was getting the first $50,000 from her dad's estate, or at least was entitled to the first $50,000 from her dad's estate, plus 1/3 of everything after that. So yeah, she wasn't too happy about her dad not doing a will after that.
Not good.
Yeah, I bet she was not happy. I'm sure she must be very angry with her dad, and he would be turning in his grave, I think.
Yeah, pretty much.
Now, I hear a lot of people, young people especially, saying there's no point in them making a will because they don't have any major asset. Is that true, Stacey?
You know, a lot of people actually say that to me when I'm talking about this sort of thing. And, like, it may be true that young people may not have, like, a house in their name or heaps of savings, but they could actually have superannuation entitlements. So when someone dies, the super entitlements, it doesn't actually just constitute what they've accrued when they've been working. It can also include something called a death benefit component, which can actually make the whole entitlement be in the thousands. So
superannuation can be distributed in a person's will, is it?
Yeah, it can be put in your will, or you can talk to your fund to see if you can actually do something called a binding death benefit nomination, which basically means that you're nominating people or a person which the money will go to if you were to pass away. So if it's binding, the fund has to give that money to those people, and therefore it doesn't form part of your will. It just goes straight away.
Okay. Now let's come back to the subject of wills. Now, Stacey, you've talked a lot before about the requirement of a formal will. Daniel, are there any other important things for a will to be valid?
Yeah, there's a couple of things. So the will maker should always be an adult, because signing a will is like signing a contract, and you have to be an adult to sign a will or to make a contract. Will maker needs to understand what they're doing, so that's called having capacity. And they should obviously be acting of their own free will. So, you know, not signing the will with a gun to their head, or, you know, with someone who's got a kind of position of power over them, kind of influencing them to make the will in a certain way.
I like your analogy about a gun to the head. Okay, now you just now Daniel mentioned about capacity. Now, Stacey, what does that mean?
Some people call it being of sound mind, and we're really talking about legal capacity here. So there's a test. So the test comes from an old case called Banks and Goodfellow, and it's evolved over time. But basically, the rules are that the person must firstly understand the nature of the will and the effects of making it. They need to understand the extent of the property they are disposing of. They need to also appreciate the claims to which they ought to give effect. And what this looks like in a more modern context is that the person making the will must understand, obviously, who they are, so like their personal details, that they're making a will and what a will is, who their relatives are and their relationship to those people, and what types of property they own, how much they own of it, and how they want to distribute it to everyone.
Okay, now that makes sense. So now what are the things that people need to think about before they are making a will? Suppose, like, let's say as a community worker, if your client is going to get a will done, Daniel, what do they need to tell those people to think about?
Yeah, so, I mean, if you are a community worker helping a client and that client's trying to make a will, you know, directing them to professional legal assistance is the best thing that you can do for them, because that lawyer can give them, you know, a lot more oversight into the things that they do need to be thinking about, and some of the, you know, legal nuances that arise when making a will. But some of the general stuff that maybe you could direct them their minds towards is, you know, who they want to be the executor of the will. So that's the person, you know, kind of responsible for administering the will. You know, the assets that they have and how those things want to be distributed. So whether they want to make some things into specific bequests, or whether they want to give away, you know, certain things in the residue of their estate, which is the gift of the whole estate. You know, thinking about who they want to benefit if their primary beneficiaries pass away, or who they want to have as maybe a backup executor. Things like if they have children, who could be looking after those kids if they pass away, although the will can't be binding in that respect, but, you know, it can express the wishes of the deceased person. And also maybe they want to put something in the will about their funeral wishes. So, whether they want to be buried, whether they want to be cremation. Again, that's not binding, but it's definitely something they can express their wishes about in a will.
Okay, now I can see that Daniel have talked a lot about wills and all that. So if you are helping your client who wants to make a will, maybe it's a good idea for you to look at our fact sheets on our website, because we have one fact sheet that's specifically for will, making a will. What are the things you have to take into account? Now, Stacy, the first thing that is mentioned is choosing an executor. What does an executor do exactly?
Yeah, so it's a really important thing to be an executor. They are basically the person appointed in the will to carry out the wishes expressed in the will by the person who's passed away. So the executor deals with the estate, the paying of debts, and distributing the assets to the beneficiaries as set out in the will. And they also do things like organising the funeral, applying for probate if needed, obviously managing the estate, collecting all the assets together, paying those debts and taxes and whatnot. And they can also look after the financial well-being of any of the beneficiaries if they are under the age of 18. Sometimes they're known as a personal representative.
Okay. Now, from what you're telling me, the executor does a lot of things. Now, can an executor distribute the assets as they wish? That means they don't follow the direction in the will and they distribute their assets to people that they like. Is there any truth in that? Because I've heard people saying that. Daniel, what do you think?
I don't know who you've heard say those things, Selva, but certainly not.
Okay,
Being an executor, you're a trustee. So the will creates a trust, and you as the executor, if you act in that role, a trustee of that trust. So you're obliged to follow the terms of the trust and not just deal with the assets as you think they should be. You must follow the terms of the trust, and if you don't do that, you're in breach of your duties as a trustee, which can have some pretty serious ramifications.
Okay, so the trustee cannot then distribute it to his girlfriend or something.
Not unless he wants to get in a lot of trouble.
Okay, now that makes sense. Okay. Now, so from what you're telling me, once a person dies, from what you're saying, I think I get the understanding that the distribution can never be changed, or have I got it wrong?
Look, yes and no. So the executor will always need to follow what's in the will, unless all of the beneficiaries collectively agree to deviate from what's in the will. So what they can do is something called a deed of family arrangement, but everyone named in the will needs to get on board with that.
Okay. So other than by all the parties agreeing, if a client have, let's say a client have of one of the community workers have been excluded from the will or left only a very small portion when compared to the other beneficiaries, what can that person who has been excluded do?
So it's going to depend on whose will they were excluded from. So, for example, if the will was the will of their parent and the parents passed away, they could challenge that will under the Family Provision Act.
So no, I thought that anybody can challenge the will if they have left out. So are there only certain people, Daniel, who can challenge the will?
Yeah, so the Family Provision Act pretty much sets out the people who are allowed to make a challenge under that act, and those people are the spouses or de facto partners of the deceased person, children of the deceased person, the parents of the deceased person. Grandchildren can do it if their parent, so the child of the deceased person, has passed away, and stepchildren can do it in certain circumstances.
Yeah, and another thing to note is that a Family Provision Act claim should be made within 6 months from the date a grant of probate is made or letters of administration. So if you have clients who are thinking of challenging a will, this time limit is really important, as it's a lot harder to challenge a will after the 6-month period has gone by.
So challenging a will and taking action under the Family Provision Act means the same thing. Is that correct?
Yeah.
Okay. Now let's get on to now that we have got an idea about the will. Now let's talk about executors. Okay. Now, is there any truth in the statement that the executors shouldn't be beneficiaries at all? Is that true, Daniel?
No, not really. For most people, they don't have access to, professional, or they can't afford a professional person to be an executor. So really having a beneficiary is as an executor is going to be the best course of action for them. And oftentimes it's helpful to have an executor also benefiting from the will, because they're incentivized to carry out their duties in an efficient and thorough manner. Whereas someone who's maybe not benefiting from the will, maybe they're kind of not really doing things in a timely manner because they've got more important things on their plate, or maybe they just choose to renounce the appointment and not act at all. That's another concern that you can have.
Okay, now let's say hypothetically, okay, Daniel, following on from you, let's say the executor is not doing their job in a timely manner, okay? What are the options available to a beneficiary? If suppose, let's say someone has been appointed as the executor and they're just let's say 1 year has passed and they haven't done anything. What are the options available to the beneficiaries?
So if you had a client who's a beneficiary of a will and the executor of that will really isn't doing their job, it's kind of going to depend on where they're at in the proceedings. So if the executor's obtained a grant of probate, you're going to have to, you're not going to go straight to the nuclear option of taking them to court and applying to remove them as the executor. You're probably going to start with maybe negotiating with them and asking them to, maybe speed up their execution. You might ask them to account for what they've done in the course of their administration. And if they're really being difficult, then you might take some court action, like asking them to pass accounts in the court or applying to remove them as the executor. If they haven't yet obtained the grant of probate, then there are some other options available to you. You could make an application to administer the estate, serving notice on the executor for failing to take that role on. All these things, though, are kind of things you'd need legal advice for, or your client would need legal advice for. So directing them to a lawyer is probably going to be the best thing to do here as well.
Okay. Now, Stacey, you're saying something about who are the best people to choose as exec. Can you give me some examples?
Yeah, so I guess a good example would be choosing your spouse or your children, if obviously the children are over 18. But you can choose extended family or friends if you like as well. Yeah.
Okay. Now, do I have to choose only one executor, or can I have more than one executor?
Well, there isn't a restriction in the number of executors you can appoint, but you should really be realistic about how many people you choose. We definitely encourage people to appoint 2 or more executors. So you could have your first executor, and then in the event they can't do it, you have your substitute. But you can have two or more as your institute or your substitutes. But if you're going to do something like that, you should really think about whether those people can actually act together. If there's conflict between them regularly, it's probably not a good idea.
I think I agree with you. Now, is it if suppose let's say someone wants to make a will and they are appointing executors, should the will maker be talking to the executors, Daniel, and asking them permission to be, if they want to be executors at all?
Yeah, most definitely. No one wants the nasty surprise of finding out they've been named the executor after the person's passed away.
Okay.
And like I said, the executor can just choose to renounce their appointment if they don't want to do it. So you really want to make sure that they're going to be happy to do it before making the will, essentially, and certainly before the will maker's passing away.
Do they have to sign any documents to agree to be executors?
No, they don't have to sign anything to agree to be the executor. You can just, have a little quick informal chat to them, or get your client to have an informal chat to them.
Okay. Now, Stacey, what's the difference? Because just now you touched on it and I hooked on to that phrase, okay? You said you can appoint them as jointly, okay? So is there anything other than jointly also?
Yeah, so, firstly, joint executors, when you say you want them to act jointly, it actually means that if you're going to have them as joint executors, they must act together. And if one of them dies or doesn't want to act or isn't able to, then the remaining executor won't be able to act either. So the other option is to appoint them as joint and several executors. So if you have 2 or more executors appointed jointly and severally, then they can either all act together, or if one of them can't do it or doesn't want to do it, then the remaining executors can act by themselves. So it's a lot more flexible that way.
God, I think I've got a good idea about executors. Now, Daniel, can you tell me, are there any assets that the deceased have that cannot be included in the will?
Yeah. So there are definitely some assets that a person can't give away in their will. A really common example that we get here is where a person owns an asset as joint tenants with another person. So, for example, real estate, there's two ways that a person can be like a co-owner of real estate. So you can own real estate as another person with another person, as either a tenant in common or as a joint tenant.
What's the difference between the two?
So a joint tenant, the major distinction for our purposes, for the purposes of wills and estates, is that when a person dies, if they own their share in the real estate as joint tenants, then their share's automatically going to pass to the other surviving joint tenant or joint tenants. So if one person dies, whoever's left on that joint tenancy automatically gets what's remaining of the property.
Okay.
And if they own it as tenants in common, if they own their share as tenants in common, then they've kind of got their own separate, distinct share. So rather than their share going over to whoever's left owning or the other co-owners, their share can actually be gifted by their will. So basically, if you own something as joint tenants and the other person's still surviving, you can't give that away by a will. And if you own something as tenants in common with another person, you can give away your share of that property by the will.
Oh, so what you're telling me is tenants in common means you own, let's take the example of a property. If suppose you and your partner own half share in that property each, your half share, you can put it in your will. But if you're a joint tenant, you cannot put it in your will because it will go to the survivor. Is that what you're telling me?
Pretty much, yeah.
Oh, okay. Now that makes sense. Now, and Stacey, anything else you cannot be included in the will?
Yeah, well, look, sometimes superannuation isn't part of the will as well, and it will come down to whether there's a binding death benefit nomination.
Oh, that's what you were talking earlier?
Yeah. So, sometimes they may form part of the will, so they'll form part of the estate if the person had a binding death benefit nomination in favour of the legal personal representative. So that could be the executor, or the trustee of the super fund elects to pay the super benefit straight to the estate. So if it's a binding death nomination to a person, like your child or your spouse, it will go straight to them. But if it's to the personal representative, then it would form part of the estate.
Okay. Any other assets that cannot be dealt with in the will, Stacey?
Property held in a trust as well.
Okay. All right. Now, so let's say that one of my client had a will drafted and the client is happy about what is the content of the will. Is there anything else that the client have to think about before they proceed further?
They need to really think about how they want to go about executing it, and that's really thinking about the witnesses.
Tell me, please, Daniel, what do I need to do?
So Stacey talked about this a little earlier in the podcast. Basically, you need to have two witnesses. So the two witnesses can be any two people over the age of 18 years. The only thing is that they can't be blind. They really should be of sound mind as well. It's a good idea. But other than that, any two people is fine. They don't have to be specially qualified. You don't need a JP or a doctor or anything like that. Any two people is fine. You probably want to avoid using anyone who has a direct interest in the will, so none of the executors or the beneficiaries or anyone directly related to those people. And it's a good idea if they're maybe independent people, so just not having a direct interest in the will.
That makes sense. Stacey, anything else you like to add to that?
Another good idea is to really choose witnesses who know your executors. The reason for this is that when you die and your executor is applying for probate, the executor has to provide the current residential addresses of both of the witnesses to the court. So it's beneficial if they know who the witnesses are so that they can easily obtain their addresses. They can't just rely on what addresses are noted in the will because they could have moved. Both of the witnesses could have moved.
Okay, now what happens if the executor can't find the witnesses at all? Daniel, can you provide some explanation about that, please?
So if you can't find the witnesses, the whole thing's not dead in the water. There's a few things that you can do. You might want to look maybe on the white pages. You might want to try the state or the federal electoral roll, the electoral roll maintained by the state or federal electoral commission, or you could try the Metropolitan Cemeteries Board. At the end of the day, if you've done all those things and you can't find them, then when you make your application for probate, you just have to tell the court, I've done everything that I could possibly do to find these people, and they're just not able to be located, and that'll be fine.
But what happens if the witnesses are dead by the time the executor is applying for probate, do you have to tell them the date of death and where they are buried and all?
Now, as long as you can tell the court that they're deceased, then that will be fine.
Oh, okay. So, okay, now we have done about the witnesses. So once the witnesses are chosen, what is the next thing that is going to happen, Stacey?
So you and the two witnesses should get together at the exact same place and time to sign the will. So you can make a little bit of an event of it. When you're all together, you must first sign the bottom of every page, and on the last page, you must sign and date the will. Both of the witnesses will also need to sign the bottom of every page, and on the last page, they will need to sign, print their name, and note their address. And something really, really important to remember as well is that everyone, so you and the two witnesses, absolutely must use the exact same pen when you're signing the will.
Stacey always frightens me with her emphasis, okay? Now, why do we have to use the same pen? And I think I'll ask Daniel first, okay? I don't want any emphasis from Stacey.
So the reason that you're using the same pen, it's pretty simple. It's just that when the will's going to probate, I think we didn't really talk too much about probate before, but what probate is it's the process where the Supreme Court is basically proofing the will, so they're just going through and making sure it is the valid last will of the deceased person. But if they're seeing different coloured pens being used on that will, one of the things that can lead them to think is that the will hasn't been properly executed because it's been signed maybe at different times, which is what different coloured pens might lead them to believe. So if you're using the same coloured pen, you're not putting that thought into their heads. They're not thinking about whether it's been executed at different times.
Yeah, that makes sense. Stacey, I think you told me something recently, a case you had.
Yeah. Well, I actually had a client that had this exact issue recently. So they brought in a will, but it had been done at home, and the will didn't have an attestation clause. And it had
What's
been
an attestation clause, Stacey?
It's a clause that essentially declares that everyone was together at the same place and time when they signed the will. Yeah,
okay.
It's part of having a valid will.
Okay.
So they didn't have an attestation clause, and they also everyone used a different pen. They're all different colours. So we were still able to help them. We helped the client get probate, but they had to give the court extra evidence to prove that the will had been properly executed. Fortunately, we were able to locate one of the witnesses who could give this evidence. But if we hadn't been able to do this, it might have made things a lot more difficult than necessary for the client.
Oh, okay. So what you're saying is use the same pen.
Yes.
Get a new
100%.
biro. Don't run out of ink.
Buy a special pen. Make it an event.
Okay.
Get together.
I can understand that. Now, can I change any parts of the will once it has been drafted?
If someone makes minor amendments immediately after or before the will is signed, then it's advisable that all three parties, so that's the witnesses and the person who's doing the will, initial the changes. However, if any additions are to be made at a later date, you should really get legal advice before proceeding. It is advisable not to make any changes to your will once it's been executed.
Okay.
Yeah, so if you did want to change your will, there's two common ways that you might do it. So one's called a codicil. So a codicil is like a document that kind of adds onto your will. It basically changes or might make some additions to the content of the original will. The problem with doing a codicil is that it basically adds another document that your executor has to prove when it comes time for them to do probate, which we talked about before, and that just basically makes the whole thing a little bit harder for them. So what we generally recommend you do here is you just make an entirely new will. So whenever you make a new will, it'll always revoke any old wills that you have, and one of the first things that you'll read on most wills, it'll say up the top, I hereby revoke all my former wills and testamentary instruments. And so when you make a new will, you just make the new will with your intended instruction, and that revokes your old will.
Now, you told me something about revoking a will. Are there any incidents, Stacey, when your will gets revoked?
Yeah, so every time you get married and every time you get divorced, it will revoke your will.
Now, is there anything, let's say I'm thinking of getting divorced from someone, but I haven't divorced them. Can I still make a will or wait until I'm divorced before making a will?
You can still make a will. It's up to you when you do it. If you do it before you get divorced, then we can put in a clause that says I'm making this will in contemplation of my divorce, so it won't revoke the will when you do eventually get divorced.
Mm-hmm.
That's the same when you're about to get married. So if you're not yet married and you haven't made a will and you decide to do a will, we can include a clause that says, I'm making this will in contemplation of my marriage to such and such, and it just won't revoke the will when you do decide to get married.
Okay. All right. Now, great. So once the will is executed and everything is done, what should I do with the will?
Well, I'm going to emphasize this a lot as
Oh,
well.
God, she and her emphasis.
It is really important that you keep the original will in a safe place. So this could be in a safe at home or somewhere like in a file at home or in a safety deposit box in the bank. You can also store your will with the public trustee at their will bank. It's a free service if you take the will there yourself, but there is a charge if someone else delivers your will to the public trustee for you, so they will get charged. It's really a good idea as well to tell your executors where the will is kept so they're not going on a wild goose chase after you pass away. You can also give copies to the executor and the beneficiaries if you wish to do so.
Okay. Now, Daniel, how often do I have to redo any will that I have?
It's a good idea to look at it every maybe few years, every maybe 2 or 3 years. Just make sure that everything in there still reflects, your wishes for the distribution of your assets and the appointment of your executors. But there's no time limit when you do need to actually redo the will. They don't have an expiry date or a best before date. So you really only need to redo it if some of the instruction has changed. So you wanted to appoint new executors, or you wanted to change how the distribution of the estate's going to occur. You don't need to change it if it's just kind of a more aesthetic feature. So something like maybe the name of a beneficiary has changed because maybe they got married or they've reverted to using their maiden name, or maybe someone's changed their address. That's not really cause to do an entirely new will for.
Also, you're telling me if suppose someone changes their addresses or if someone reverts to their maiden name, you don't need to make a new will.
No, the legal effect would still be the same.
Okay.
It's still appointing the same person. They just, maybe when they're making their application for probate, they'll just have to address the fact that they're now using a different name than how they're described in the will.
Okay, that makes a lot of sense. Now, in summary, Stacy and Daniel, let's summarize let's distill everything into 3 things, okay? What are the 3 things that you think that is important for a community worker to take away from this podcast? Daniel, can you start first of all?
For me, it would be about if you've got a client who is going through separation, they can make a will. Obviously, things that they have in joint names, we talked about that rule of survivorship before. Things that they have in joint names, they can't make a will for those things because they'll go to the surviving joint tenant, but they can make a will for assets that they've got in just their name. But it is important that that will is made in contemplation of the divorce, because if they do get divorced and the will doesn't have that contemplation of divorce, the will's going to be revoked by their divorce.
And now, you did mention during the podcast something about marriage also, Daniel. Can you tell me something about that also? Because some of the clients that the community workers have may be thinking of getting married and all.
Yeah.
So can you talk about that also, please?
Yeah, so marriage again is another thing that can revoke a will. So if you've got a client who's going to be getting married, they would also need to make sure their will was in contemplation of marriage, because otherwise their marriage will revoke the will as well.
Okay. Now we come to Stacy, who is always emphasizing things. Okay, her favorite theme is executing the will. Okay, Stacy. Here we go. Now she's going to frighten me with her emphasis. Okay, if someone is executing the will, what do you think are the important things?
Well, having the 2 witnesses and the person who the will maker is all together at the same place and time and all using that same pen. Really want to drive that home. It's really important. And just in relation to the witnesses, just being really careful about who you choose to have as the witnesses. So obviously, it's not advisable to have people who are named in the will, such as the beneficiaries, as the witnesses, but you might want to consider maybe extended family of, your spouse or someone or people like that. So no one too close to home, but someone just removed enough that the executor will be able to reach them to find out where they're living at the time probate's being applied for. And I just want to make a quick note about will kits as well. So if you have a client that does approach you wanting to do a will kit, just be very vigilant. In fact, it's really probably a good idea just to leave it to the professionals.
Thank you. You don't go and pull your teeth out when you have a toothache with a tool from the shed, okay? So you want to do a will, go to a lawyer. Now, another thing that I have heard about, sometimes people like brothers and sisters have been left out of the will. They want to say, oh, I want to challenge my sister's will because I have been left out of my sister's will or my siblings' will. Now, it's very important to realize there are only certain groups of people who can challenge the will. If a spouse have been left out of the will, doesn't matter whether they are married or a de facto spouse, that de facto spouse or the spouse can challenge the will. Children can challenge the will if they have been left out. And then the other person who can challenge the will is the parent of the deceased or the will maker. And in some circumstances, the grandchildren, I think, from what I can glean from what these two experts were talking about, that grandchildren can challenge the will if their parent is dead and the grandchildren are now standing in the shoes of the parent of the child of the deceased. They can challenge the will. And I think stepchildren can challenge in limited circumstances. Have I got that all correct, the two of you?
I think that's everyone.
Okay, I wanted to be sure I haven't left anybody out. Well, thank you very much, okay, for taking time to do this podcast, and I hope it will be valuable and useful to people out there. Bye, everyone.
Thank you.